Good afternoon and good morning. 大家早上好. Welcome to the UN Global Talk Series on Generative AI and Human Creativity. This talk series aims to bring together different voices in a generative AI ecosystem, shedding light to the various dimensions of the AI impact on human creativity. And in light of these dimensions, brainstorming on how the IP system should address the AI challenges in a more systematic way. So today's talk will focus on the fair use defense under US copyright law. We might have another session coming up to touch on the copyright issue and the fair use issue and copyright infringement in China later this year, as more cases come up and discussions unfold. So as we know, copyright law rewards human beings' expressive originality by crafting out certain exclusive rights for the creator, such as the rights to make copies, to distribute, to prepare derivative works, and in jurisdictions where authors' rights are heavily emphasized, to rights to attribution and to the integrity of work, etc. Meanwhile, copyright law also recognizes that much of the human creativity is cumulative in nature, meaning that despite now originality, our individual sparkles, we all have to draw inspirations from other people's works. So to balance the protection of individual originality and necessary access for cumulative creativity has been a theme challenge aimed to be addressed by copyright law from its early days. And over the centuries, copyright law has developed several safety valves to achieve this balance, including the so-called fair use defense. In a nutshell, the fair use defense means that even though one person's use has in fact infringed on another's exclusive rights, in some situations, it should be excused. Globally, there are two primary approaches to fair use. US represents one that's more open-ended and flexible, talking about the four-factor framework we'll discuss a lot today. And the other is the approach taken by China and EU, where only legally prescribed limitations may be excused. So over the centuries, judges and legislators always struggle to strike a better balance of the exclusive rights and access interest using fair use as one vehicle. Now, as we step into the so-called AI age at this astonishing speed, this challenge seems to be getting more complex. On one hand, as discussed in earlier talks, the Gen AI tool does have potential to bring huge benefits to human beings, including acting as this very powerful tool to assist human innovation and creativity and creation. I like to use the metaphor of a centaur creator with human beings' head representing its judgment and sense of direction, and horses' legs representing AI's horsepower. And to perform really well, at least the current LLM, large language-based, model-based AI algorithms do need troves of data, which may include lots of copyrighted works, excuse me. And individual licensing is virtually impossible due to exorbitant transaction costs. So there seems to exist a valid concern of anti-commons in the AI training context. On the other hand, though, ingestion of these copyrighted works created by human artists as, quote, raw materials makes the Gen AI tools capable of generating homogeneous outputs that may compete with human artists whose very creations they fed on in the first place. So an overly lenient fair use defense, which allows these machines to freely learn without compensating or even recognizing the original contributions, seem to violate the very principle of IP and equity. So in light of this tension, the theme for today is how should we apply the fair use doctrine to the use of copyrighted works in a Gen AI training process, assuming that such use has been found to infringe the author's exclusive rights to reproduction and derivative works. I know some friends may argue that such use does not infringe any rights in the first place. And I think in some exceptional cases, they may have a point, but I do want to untangle the picture a bit and focus on the fair use defense only today, which by itself is complex enough. I'm very glad to have two well-esteemed Berkeley colleagues with me today, Professor Peter Manel and Professor Robert Mudges. For many friends in the audiences who belong to the IP circle, they don't need my introduction. Among many amazing achievements of them, they co-founded the Berkeley Center for Law and Technology almost 3 decades ago, which has been ranked as the #1 IP program for 19 consecutive years. So suffice it to say that in my mind, they are both extremely, extremely careful and well-balanced scholars. So without much ado, let's start the talk. So Peter, maybe in the beginning, could you please introduce the fair use doctrine so that our audience will be on a similar page?
Thank you, Dr. Howe. And it's a real pleasure and honor to be participating in this series that you've been putting together. I'll say a few words, and then I'm going to do a lecture format. I'm going to put some slides on the screen just to kind of get everyone to a common background. But what I would like to say before we jump into this topic is that we're living through a very rapid technological disruption. And this is somewhat familiar to those of us at BCLT, just because we started our center during the digital revolution. We encountered the internet revolution, mobile, etc., file sharing, and those kinds of issues. And now we're on the cusp. Well, we're past the cusp. We're well into this very dramatic technological story that's unfolding. And what I hope to do is to set a background for discussing this area. The fair use doctrine is centuries old, and it serves as an adaptive mechanism. But as we'll see, it has been pushed and pulled during the last few decades. And the most recent Supreme Court decision, the Warhol decision, I think restores some of the balance that was intended in the legislation. All right, so this one slide gives you the long history. You can see the concept of fair use emerged in an 1841 judicial decision by Justice Joseph Story, one of the most celebrated jurists in American intellectual property jurisprudence. And it existed purely as a jurisprudential doctrine for the better part of 200 years. During that time, the US Supreme Court never addressed it. It was pretty much driven by decisions from the leading circuit courts, most notably the Second Circuit. But going into the mid-20th century, there was an effort to bring it into the statute. And so we had codification in 1976, and that didn't produce a clear doctrine, and that led another noted jurist, Pierre Laval, to suggest this notion of transformativeness as a way of integrating some of the features. But that led to a new series of cases that added to confusion, and the Warhol case brings us to, I think, a restoration of what Congress had initially intended. So let's begin the story with Justice Joseph Story, and he was dealing with a case involving the papers of the first president of the United States, very important historical documents. And in the context of a case in which these letters, which are protected by copyright, were republished, he explains that patents, as well as copyrights, approach near any other class of cases the metaphysics of the law, involving very subtle and refined and sometimes almost evanescent distinctions. And this is something that those of us who teach in the area are very familiar with, and students are frustrated by. In cases of copyright, the identity of the two works in substance and the question of piracy often depend upon a nice balance. And it's from that we derive this notion of fair use. Now, interestingly, the case ultimately ruled that the republication of these letters, even though of enormous historical importance, was not fair in Justice Story's mind, but he planted the seed. And over the next 150 years, we see the development of a fair use doctrine. But by the mid-20th century, there was this sense that the doctrine was very uneven in application, and it could benefit from inclusion in the omnibus reform that began in the mid-1950s. That ultimately came to fruition in the 1976 Copyright Act, so 2 decades later. But the process began with a series of studies, and a leading practitioner, Alan Latman, produced the study on fair use, study number 14. And in summarizing that vast case law that emerged, he recognized 8 different contexts in which courts had applied and recognized fair use: incidental use, review and criticism, parody, scholarly works, personal and private use, news, use in litigation, and use for nonprofit or governmental purposes. He noted, however, there was widespread agreement that it is not easy to decide these cases. So when the Register of Copyrights went about proposing a new framework for what would ultimately become the 1976 Act, that first register's report, 1961, there's a proposal to draw from the Latman report the 4 factors that later became the core of the fair use doctrine, the statutory version, section 107 of the statute. And the register recommended codification. Now, this was controversial. Many of the commenters on Latman's report were equivocal, or even against anything more than just having courts continue this process. And over the next 15 years, there's back and forth on whether and how to codify the statute, but it eventually comes to fruition in section 107. And here's the final version in the 1976 Act. There was later added a provision having to do with unpublished works, but this is where it was in the 1976 codification. Few notable things. It has the 4 factors that were part of the original design. And the legislative history talks about not changing or narrowing or enlarging the kinds of uses that had been found to be fair use. And if you notice that the preamble of this provision refers to criticism, comment, news reporting, teaching, scholarship, or research. And so those purposes were carried over really from the Latman report. Interestingly, there's no mention of parody, but as we learn in the Campbell case, that gets rolled into this notion of criticism or comment. The legislative history for the final version of the statute explains the logic. They say there's no disposition to freeze the doctrine in the statute, especially during a period of rapid technological change, although how that change cuts is hard to say because other parts of the legislative history refer to the importance of protecting authors. And then the final sentence of this section says that this provision is intended to restate the doctrine as courts have developed it, not to change, narrow, or enlarge it in any way. Following this decision, the Supreme Court began, barring this legislation, the Supreme Court began to take up the question of fair use. And we have a series of cases beginning with the Sony case, the Harper and Row case, and eventually the Campbell case. And these cases didn't fully clarify the law either. They added to confusion that was already apparent in the appellate courts. Judge Laval, who had been reversed in some of those decisions, was motivated to write an article in which he tried to boil down what he thought was the core of this fair use doctrine. And he says that this notion of transformativeness is at the heart of the doctrine. The use must be productive. It must employ quoted matter in a different manner or for a different purpose from the original. If the secondary use adds value to the original, the quoted matter is used as raw material, transformed in the creation of new information, new aesthetics, new insights and understandings. This is the very type of activity that the fair use doctrine intends to protect for the enrichment of society. He did not, however, intend to say that this substitutes for the right to prepare derivative works, which we know from the statutory definition includes transformations of original works. And also, he's not intending to supplant the four factors. And this gets taken up a short time later, a few years later, in the Campbell case involving a use of a very famous song, Pretty Woman by Roy Orbison. And it's retold in a parodic, critical vein by the band Two Live Crew. And in his deposition, Luther Campbell says that he was trying to criticize this romantic version of a streetwalker. The woman referenced in Pretty Woman is a prostitute. And so he is either well prepared or a very thoughtful literary critic, but in his deposition, he's clear that there was a purpose behind these lyrics. And the Supreme Court, taking this case up, recognizes Judge Laval's article and brings it into Supreme Court jurisprudence. It talks about whether a work is superseding the objects of the original creation, or instead add something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. But again, like Judge Laval, there was no intention to supplant the four-factor test with a singular focus. In fact, the decision goes into a lot of depth in trying to play through the four factors and notes that there has to be an independent justification for a use to qualify. In this case, it was a parody justification. But even here, the court didn't resolve the case. It remanded the case was settled. So we don't have a formal resolution of whether or not it was fair use, but the use was authorized through the settlement. So the Luther Campbell Two Live Crew song continued to be available. So a case shortly after that involved a very deep dive into the four factors, and it hits close to home. It has to do with scholarship and research. But unlike Dr. Howe and Rob Burgess and I, this was a commercial context, not an academic context. And so as a bellwether focus, the parties agreed in a case in which Judge Laval was the district judge to focus on the photocopying made by one particular scientist at Texaco. And they went through his files and they saw that he had received the journal Catalysis through a circulation process. That's completely legal. If a journal is acquired, it can be passed around without violating copyright law. But what he would do as his routine approach, and he was chosen as the bellwether, is he would photocopy articles that were of particular interest. And so that created this issue. Were those photocopies, which were done for a purpose of scientific research, which is a further purpose, it wasn't merely to sell copies, it was to further his research, but it was done at a company, and there were alternative ways in which they could have gotten permission to get those copies. So what we see here is a very careful assessment of all factors with particular insight into the fourth fair use factor, the effect on the actual or potential market. And the court notes that buying more copies of the journal wasn't the only way in which revenue could have flowed back to the publisher at perhaps a manageable transaction cost. The court identifies the Copyright Clearance Center, which is an institution that enables this kind of per article copying to go forward, as an effective institution that pushes the balance towards this not being fair use and something that needed to be compensated. Now, there's a dissent in the case, and I think it's a very interesting, deep case. I think there's an argument that that isn't a very effective institution, but both Judge LaValle on the lower court and Judge Newman on the appellate court concluded that when balancing all the considerations and the lack of a real transformative alteration of the work, that this was not fair use. Well, things really picked up at that point. A cadre of copyright scholars began to push courts to read transformativeness very broadly, leading to the collapse of fair use into whether a secondary work added something new with a further purpose or different character, altering the first with new expression, meaning, or message. Just as Campbell says, but without all of the other detailed analysis that was in the Campbell case. And so we had cases like Blanche v. Coons and Caruthers' Prince, where photographs were taken and repurposed as part of collages. And in those cases, the court said, well, these are different. They're new. They transform the original, and that's enough. Now, there are dozens of cases, more than 100 cases, in which this notion of transformativeness becomes the central focus. What started to shift the analysis was a case that emerged in the Ninth Circuit, and it had to do with a book that tried to transform a very popular book called Oh, the Places You'll Go, Dr. Seuss's last book, and arguably his most successful, certainly his most profitable. This book became and continues to be a staple every May as students are graduating. And it tells the story of a cute character who goes off into the world, and it's an ideal graduation gift. And so the authors of the secondary work, Oh, the Places You'll Go, remixed the Dr. Seuss work with Star Trek lore. And as you can see, I'm a pretty big Star Trek fan myself. I've got the Star Trek Enterprise over my shoulder. And when you look side by side at the images, you can see that they rather slavishly reproduce a lot of the art that Dr. Seuss had created. And as much as I liked Star Trek, I couldn't easily justify this as a fair use, given that Dr. Seuss Enterprises was licensing its characters and its works into a variety of other markets. And I decided to lead an amicus brief where we said that if this qualifies, then really any work can qualify. And the Ninth Circuit picked up on our brief and said the unrestricted and widespread conduct of the sort comic mixes engaged could result in anyone being able to produce without Seuss's permission, Oh, the Places Yoda Go, Oh, the Places You'll Pokemon Go, Oh, the Places You'll Yada Yada Yada, and countless other mashups. Thus, the unrestricted and widespread conduct of the sort engaged in by the defendant here could create incentives to pirate intellectual property and disincentivize the creation of illustrated book, which is contrary to the goal of copyright to promote progress of science. So this created the circuit split that leads to the Warhol case. Lynn Goldsmith photographed a young artist known as Prince, in 1981, and this gets licensed to Vanity Fair for a work prepared by Andy Warhol when Prince hit it big. And the Purple Fame piece features this Warhol derivative of Lynn Goldsmith's photograph, and based on the license agreement includes source credit and payment to Goldsmith. But unbeknownst to Goldsmith, Warhol, as he was known to do, created multiple images, in fact, 16 total images. And that was revealed when Prince tragically died in 2016, and Vanity Fair and Condé Nast went back to the Warhol Foundation wanting to relicense that same work. And they said, well, we actually have others. And they decided to go with the orange Prince. When Goldsmith saw it, she complained. The Warhol Foundation brought a declaratory relief action seeking to say, seeking a court to say that there was no copyright infringement. She filed a counterclaim for infringement. And although the district court said that this was transformative, on appeal, Judge Lynch upped the threshold, recognizing that the Cario case in particular had come under heavy criticism. And here he said that in order to qualify as transformative, there has to be a fundamental different and new artistic purpose and character, and that wasn't met here, which seemed, I think, a sensible correction for where the Second Circuit's jurisprudence had gone, but then the Supreme Court granted. And that raised this question of, well, are they going to overturn this decision? And like the brief that I co-authored in the Dr. Seuss case, this struck me as a clear case of having to reconcile the fair use privilege or defense with the right to prepare derivative works, which are defined as works that recast, transform, or adapt an original. In the brief that I co-authored with Professor Balganesh and Professor Jane Ginsburg, we suggest that there has to be a heightened threshold. We said it has to go beyond, and that's something that perhaps independently or perhaps derivatively shows up in the Warhol decision. And the decision does a much more thorough breakdown of the first factor. The Second Circuit's resolution of the second, third, and fourth factors was not appealed. So it's important to recognize the Warhol decision is really only a factor one decision. And the decision emphasizes the need for an independent justification. And in this case, that was arguably lacking, and the need for a distinct purpose. And here the court notes that the purpose that it was seeing was a portrait for a cover of a magazine commemorating Prince's career and his life. And they gave as one of the exhibits a variety of these and said, these at the level the court is doing the analysis is where we should go. We shouldn't get heavily into art criticism for this kind of purpose. Condé Nast would have been happy perhaps with any type of portrait, but what you see here is the court says, we're not going to just evaluate and say, is this better art? We're going to try to really determine whether this use is justified, and there has to be an independent justification and a distinct purpose. And then finally, we have to actually weigh the transformativeness against the commerciality. In the Campbell case, the court said there's no presumption that a commercial use is unfair. And courts had really pushed the whole issue of commerciality out of the equation. And the Supreme Court reminded us that this is actually in the statute. We have to carefully assess commerciality and do some sort of balance. And this only gets you through factor one. The other factors were not under review. So what I see here is perhaps coming full circle, restoring what was the intention of Congress, which I'll say was not, I think, perhaps the view that many scholars preferred, but I do think it's faithful to what the statute and the jurisprudence had acknowledged. And when I say jurisprudence, I don't mean what happened after Campbell. I think the Supreme Court focused, as it does, on its own jurisprudence. Now, it's important to recognize that this is only one part of the fair use story. Campbell and Warhol provide the guiding framework, but they're only part of fair use jurisprudence. Another important branch deals with functional uses of copyrighted works. And to deal with generative AI, we have to bring these cases into focus as well. So one of the very important cases from the early 90s, one that I think was correctly decided, I was part of a brief that was filed in this case that proposed that this was fair use. And this had to do with the software code that enables a video game to run on a console. And Sega tried to control who could write games for its console, and it protected that code, and you had to license it directly. But Accolade, which developed games for a range of platforms, didn't want to go through that process and had other ideas in mind. And so they acquired the games, and they made hundreds of copies so as to determine what were the key zeros and ones that needed to be fed into this console in order to unlock the device. So it's a purely functional use of zeros and ones, or we can call it expression, but it's not. It's a functional expression. It's essentially like the shape of a key. And so was that intermediate copying a violation of copyright? Because the ultimate use was really only to take those few bits that were necessary. And so it brings in this whole issue of reverse engineering. And what Accolade did was they had one team that studied the code that Sega created to determine what was minimally necessary, and then provided that code over a proverbial wall into a clean room where another group of programmers unfamiliar with the full code could write fresh code and only use the functional specifications. And even though the ultimate products competed with products that Sega had a financial interest in, the court determined that this type of copying was authorized because it was only being used in an experimental sense to figure out what elements were necessary for interoperability. Another interesting case has to do with software that is used to identify plagiarism. So iParadigms ingests large amounts of student papers and other materials just so as to provide a check on whether work that's submitted is original. And the Fourth Circuit in this case said that the archiving of the plaintiff's papers was transformative. It was being used not for the content of those papers, but merely to determine whether or not they were being used in violation of an honor code. Another important case that came down in this area had to do with the Google Books service. Google Books service involved ingesting full copyrighted works, books, and then enabling users using Boolean search commands to identify books that have short phrases. So it returns snippets. It has guardrails to prevent the return of, say, poetry or other shorter works. And Judge Laval appears again in our story. He's on the appellate panel. He writes the opinion. He says that this type of use is, in his view, highly transformative. I don't know that you need to use that terminology. I would say it's entirely functional in that it's enabling people to locate works. It's not competing with those works. In fact, it's providing references to where you can gain access to those works legally. And he identifies the important public purpose that this kind of advance, this technology produces. And that brings us to another important Supreme Court case that I think will play out in some of this generative AI litigation, and that involves Google and Oracle. It's a very complex story, so I can't go through all the details, but I'll just highlight that Google recognized when the iPhone came out that they needed to have a competing platform. And that's what led them to hire Andy Rubin and to start developing the Android product. And these are exhibits from the trial. And one of the important realizations that they made in 2005 was, in order to get rapid adoption of this technology and to make it especially valuable, they needed to use Java, not just the language, but also the application program interfaces, which are sort of like paragraphs of code. The Java language was freely available. Sun had released it for widespread use, but the paragraphs of API code, those were not released for free use. And so the Google team realized that they would need to use it. They were confident that they could get a license. Eric Schmidt, after all, had been the chief technology officer at Sun when Java was developed. Of course, he'd be able to cut the deal. But when they started the negotiations with Sun, which was having deep financial problems, they reached an impasse. Sun was insistent that anything that used this API had to be released in the general public license open source model, that it had to be completely compatible with the standard edition of Java, the Java platform. And there was disputes over how much Google should pay for this and how much control they should have. So Google ultimately walked away, said, well, we've read this Sega Accolade case, we can do that. And they did. And it was even easier for them to do it because in this case, the application, the functional specifications were published by Sun and later Oracle. So they didn't even have to do the reverse engineering. They really just had to write code with people who were only going to have the functional specifications fed to them. And so when you looked at the hundreds of thousands, millions of lines of code, you can find snippets from the Java API, but those are necessary in order to have interoperability of these commands. I won't go into the Lotus Borland litigation, but there's some similarity there as well. Using these labels was important, and most of the code didn't involve those labels, but was written independently. I've only, on the top layer, shown where the similarities are. All the background code is different. And so Google, in a case that eventually made it to the Supreme Court after nearly a decade of litigation, contended that they qualified for fair use. Now, I frankly think that what they copied was unprotectable to begin with. So I don't even think they needed to get to fair use. And that was the brief that I had filed in the case. But Justice Breyer, I think in order to build a strong majority, said, we're going to do this under the fair use rubric. And what he does in this case is very interesting in that he reorders the fair use factors. Because in a case like this, the second factor, the nature of the copyrighted work, is really primary, because the works here are so thinly protected that that should play especially large. And then he works through the other factors, and Android fares well. And icing on the cake is that he recognizes that it's important to take into account the public benefits of copying and having a competing ecosystem to the Apple iPhone, enabling the millions of programmers familiar with the Java APIs to be able to implement them, even in differing code that interoperated, was of great benefit. And he says, we don't say this is going to be true of many cases. This may be very unique to this case. And the computer programming context is also somewhat unique. But we see this sort of added ingredient in the fair use jurisprudence. So we might ask, what does this mean for generative AI? And I'll say I'm still learning, and I don't want to say that I've figured this out. this is going to be a case-by-case assessment. And so anyone who I think is saying that there's going to be one sort of global case that resolves this, I'm skeptical of that view. I think that we're going to be involved in a multi-year process, just as we did with Google and Oracle. And it's going to take a while. And because the use cases vary very much, that is going to mean that there won't be a one size fits all. I think we're going to see a variety of different approaches. Now, one of the things that I've come to believe, even in the sort of year and a half that we've had ChatGPT and these very powerful technologies widely available, is that I think that experimental uses of this technology to determine cures for cancer, to address climate change, to solve scientific and technological problems, I think that these uses, even if done for commercial benefit, ought to be immune from liability. In fact, in a paper I'm working on, I would contend that Congress should just put that into the statute, that we should have a clear statutory exemption, because I think scientists working in universities and even in industry ought to be able to ingest all knowledge that they think is helpful, that will guide these machines to potentially identify these important public advances. And so even if those cases don't get resolved by a statutory change, I do think that the law will favor those uses, because the ultimate output, so rather than getting to the question of whether you're ingesting only functional information, which I think is very hard to determine ex ante, I think we can focus on the use case and the output. And if the output is a new drug or a better way to make a battery, I don't think that implicates copyright. I think it's perhaps closer to the iParadigms case than other uses. And so I think those are easy cases. But we have a whole bunch of cases where graphic art, music, news, a lot of different uses that are going on that are much closer to the markets for the works themselves that are being ingested. And even though you can't easily, in some of these cases, attribute the output to the input, and I know AI researchers are very much trying to better understand how neural networks determine the outputs, I do think that we are going to be in fair use controversy, and there's going to be a lot of need to learn more about the technology and develop a record on which the four factors can be applied. I'll also note that I think some of the important players already recognize that it may be better to ask permission than forgiveness in some sense. There's certainly a sense in which they are jumping the gun and using models and releasing products, and that has led to the excitement in this area. But I'll say, from having used these products, it's not hard to generate infringing works, and I don't know that the guardrails are going to protect these companies, because there aren't many guardrails, even though there are some being put in place. But what you do see are companies like Getty, which own a tremendous portfolio, or Adobe, that have a lot of authorized works, and they are building products that are generative AI based. And that's, I think, important if we're going to have, an ecosystem that's good for creators and the technologists. I would analogize that a bit to what happened with file sharing. That when file sharing began, there was really no compensation for artists. I mean, there were arguments that artists benefit because more people have access to their work, but what we've seen with Spotify and in the film context with Netflix, that these ecosystems are much, I think, more balanced in terms of motivating creativity and distributing the value. The other thing that's happening, and even I think yesterday it was announced that OpenAI is starting to license data, including a new announcement that they're going to be working with the Financial Times, important financial publication. They've already got deals with AP and Axel Springer. So this is going to, I think, very much come into our story because courts struggle to determine whether or not under Factor 4 there's an actual or potential market. I think we've already seen indications that there is a potential market and now an actual market for training of these this data. So here's just some of the cases that are going to come into play. Rob and I will try to explore some of that terrain.
Thank you very much, Professor Manel. That was a very informative introduction. I also appreciate that you started sharing some of your thoughts of applying that, the framework, including the recent Warhol versus Goldsmith case to the AI training context. So I absolutely agree with you that this is extremely difficult challenge for the AI training context, and there should be case by case analysis, no size fits all, and I think now might be a good time, for us to really live the question. If I can cite a famous German poet, Rilke's famous line to a young poet that don't rush to answers, leave the question for a while, because that's just necessary. So if let me turn to Rob for now. So Rob, if I can roughly summarize the current AI fair use arguments, the way I see it, there might be three primary types. The first is heavily arguing the transformativeness, which it was the first factor, as Professor Manel introduced. And the second would be the so-called, some scholars frame the Google Books book or the Saga Acklog cases into the non-expressive uses. Basically, it's the computer programs in those cases take the non-expressive part, not the expressive part. So, and the third type would be the market failure argument. Basically, market transaction costs be too high. So I think, maybe just could you please also share your thoughts on how you would advise to give some guardian rails of application of the fair use doctrine to address these kind of arguments. So, Professor Manel, maybe I can turn back to you while Rob is dealing with the difficulty technology there. Is that I do want to hear some of your thoughts on the so-called non-expressive uses. I know no court actually used that phrase, but that some scholars frame those cases into non-expressive uses. But to me, it does sound, have certain persuading power to argue that.
Yeah, I hear your question, and I do think that one can try to develop an argument saying that non-expressive uses are outside of copyright protection, but how do you determine that? So where I am comfortable using that is where the output, like a reverse engineered key or a use that is really just to determine whether there's some plagiarism or some fraud or some other purpose. I think those those are cases that can be assessed. But when you're ingesting data into a system, and some would say that that's to teach the system to learn, and it's just like when a human hears music or reads books, that we're doing that, but we're not storing and fixing that information in the way that a computer would. And the other thing is that this is being done on a massive scale that I think changes some of the balances that, and so there will be some very interesting, I think, case-by-case questions. So think about the New York Times case or the Reuters case. These are cases that involve fairly thinly protected works if we're merely talking about the facts and news stories or the head notes.
Testing this.
Westlaw.
Sorry.
Sounds better, Rob.
Better? Yes.
Yeah. So let me just finish. Let me just finish this
Sure.
thought, and then you can jump in. So what I would say is that we can't know at the ingestion stage what is being ingested and how it's being used very easily. If you're, as some scholars have suggested, you're by vectorizing expressive works, you're able to ex ante distinguish idea and expression, that you're able to remove the facts and make them separate from the way in which the facts are told and things of that nature, then that would be fine. We've never thought that was very easy to do. We've had, decades or centuries of jurisprudence that struggle with those questions, and fair use as well. So I just think that we can make some categorical judgments based on the outputs, that there are certain outputs that I think ought to be clearly excluded. And I would favor having that done in the statute, just so that a researcher at our university wouldn't have to worry. I mean, I think that the initial research on AI, generative AI, was fine. But now companies have raised, tens of billions of dollars, and they're going out into the world with commercial products that will compete with the products, or at least in some cases, products on which they were trained. And that's just, it's a new situation. That's not Authors Guild. That's not any of the cases we've seen yet. It's certainly not Sega versus Accolade. So I just think, as in the Texaco case and in other cases like Campbell, developing a rich record is going to, get us moving down this path. And I think that it would be nice to have some of these clearer issues just resolved legislatively. Judges are going to struggle with this, and it's not like the first judge to hit on it is going to resolve it. So, these cases are piling up, and, I do think, I know that no one thinks Congress is that anxious to jump in, but, we've seen in the IP world that letting courts resolve these issues, has both pros and cons. And we know that this is going to take a long time to resolve. And so, these are interesting questions. What is perhaps moving us forward is just that companies are starting to develop these walled garden approaches and starting to build more focused products, and building these products in a more, I think, balanced way that perhaps is addressing the bigger social issues that I know we're going to deal with, which is, how do we create ecosystems that are supporting the full range of creators?
I hear you. I'm really, if I just add one quick comment, I'm really glad you included Texaco case in your slides, because in my opinion, that case didn't get sufficient attention, because it largely addressed the question of, if the human scientists in those cases, they copy the whole paper, but they only take the functional part. Does that photocopy itself still, could be excused with fair use? And at least in that case, the court said no. Okay, let me.
Well, one thing about the case that's very interesting is the court, the lower court and the appellate court, deal with the hypothetical or the real world scenario. If you and I are reading an article in the Journal of Catalysis, and if we take notes during that process, that note-taking is essentially extracting factual information and unprotectable information, and that would not, I think, be seen as an infringement. It does involve copying, but it's copying of And in the Texaco case, the second factor was found to favor Texaco and not the publisher because the articles themselves were scientific. But that's different than photocopying the entirety of the article. And it's certainly different than photocopying the entire corpus of knowledge.
Exactly.
And those are the kinds of questions we're going to have. And it's very hard. It's not like Spotify where we can attribute my listening of a song to a particular, song. It's so we don't have a very good measurement system, but society, I think, has to confront how can we steer this exciting development in a way that we are able to maintain robust, creative, and innovation and innovative progress. And I think anyone who thinks that just saying everything is freely available, I'll say I'm not persuaded that that's the right answer. It may be a pragmatic answer. It may be the best we can do, but we're still at an early stage, and I think we can do better. These kinds of arguments were made about file sharing. And I don't think we would have benefited from immunizing the file sharing companies.
Right. So let me turn to Professor Mudges. Due to the time limit, maybe we just focus on your opinions on factor 1, and particularly I want to hear opinions on factor 4 because of your scholarship almost like 3 decades ago. But let's maybe focus on the transformativeness in factor 1 first, if I may, if you may. What's your opinion, Rob, post Warhol, this framework?
Okay. Yeah, I think now Peter has covered the landscape pretty well. What I would add, especially on factor 1, would be I think before we even consider fair use, to me, we have to confront the fact that fair use has sort of swallowed much of copyright law. Peter mentioned in the Google case, we jumped right to fair use, when many of us would like to have seen some discussion of the copyrightability, the protectability of the API codes because they're functional. And I think that's a lesson going forward. For me, I would like to see a return to the recognition fair use as a defense. And so the first step is to think about liability. And should it be there? Is this the type of work that should be protected? And much of what Peter was talking about in terms of functional works, they're not protectable, right? So I think we do a disservice to jump right to fair use, even factor 1, because that's not meant to preempt questions like Baker v. Selden, or is this an idea or an expression? I mean, the nature of the work is the first factor consider for a work that's been found to infringe copyright, right? So that doesn't, swallow up all considerations of liability in the first place, to me. Then I guess on factor 4, I completely agree that Warhol has, pushed the reset button in my mind in a positive way, because the sort of preemptive force of deciding that the nature of the work is a protected type of work, that really steals a lot of thunder from factor 4. You, in a sense, never really get to a full discussion of factor 4 if you start by saying, this is already an exempt work, this is a transformative work. So I think people have done studies on this, but I don't think there's ever been a case that said, yes, it's transformative, but it affects the market significantly, so it's not fair use. Usually, in the same way fair use has swallowed copyright law, factor 1 has swallowed fair use. So I'm glad to see consideration of factor 4. To me, that's a crucial factor. And as the legislative history that Peter quoted pointed out, in that report, it was said to be the most important factor. So if anything, we ought to start with 4 and then, go backward, 3, 2, 1. We shouldn't, take that transformative off ramp from the full fair use analysis, in my mind. So then the second general point I want to make is that even before we think about US copyright law or Chinese copyright law, we should think in the big picture, what's the general shape of the problem? And the problem is that we have a technology that harms third parties. We have a technology that has all kinds of, great potential and some, success stories, but it throws off side effects that hurt innocent people. The innocent people are the creative community whose work have been ingested into a potential, preemptive kind of creative jukebox that's going to spit out competitive works, at least for some of the creators. So the first stop on that train is to recognize that the infringement is a harm that's meant to be cognizable in the law. We often would say, well, a blender that can tear up your fingers, there's a harm we all agree is a bad thing. But starting with file sharing, Peter said, there was a kind of a pushback on that when the harm related to copyright. A lot of people either discounted the type of harm that infringement is, or said it doesn't really harm, it helps the authors. They're just too stupid to realize that. They're actually benefiting like crazy from file sharing. We heard that a lot. And then I think, last but not least, was a sort of victimless crime, especially because in that era, people said, well, the real beneficiary owner of copyright is big companies, right? So we're not hurting individual artists, we're hurting publishers and record labels, a couple of rich executives, stockholders, basically people who can take the hit and people whose harm is so distant and attenuated that we don't have to count it as a harm, right? It doesn't really count. Well, if you follow what happened in the music industry, which Peter does closely, that was not true. There were a lot of artists who were harmed. The old ecosystem had its downsides, but overall compensation, especially for recorded music, has dropped. It used to be a sizable chunk of many musicians' income stream, and it's cut to very small now, partly because of Spotify's payment model, but just generally.
I just want to clarify. No, I think it has rebounded in a healthy way, and just as when the New York Times put up its paywall, its business became more sustainable. No, I think music and film have thrived because we dealt with file sharing, and I don't think the file sharing is a fully apt analogy for what's happening now.
Well, no, I was talking about general attitudes towards
Right.
copyright-related harm, where I was going.
Yeah, no,
and then
I agree with that.
Yeah, and you could see from Breyer's opinion in the Oracle case that he was entertaining this cost-benefit sort of approach. And my first point was just, it is a real cost. I think if some AI output displaces some human creative professionals, and something I care about, I want to fairly count it in this cost benefit analysis. So that gets to the question of licensing markets. And I think living the question is the right approach. We have a lot of uncertainty. So part of what I would recommend is don't make any irreversible decisions too early in the game. because they will lock in and become a kind of a fixed, reference point, and it becomes hard to change policies that are set early. The hardest change in particular is to go from, we decided we don't need property rights here. Oh, now later we think maybe we should have. Once the cat's out of the bag and people are used to getting stuff for free, markets are set up, and companies are built around a free content model, it's too late. So if you're going to err, in my opinion, the more reversible decision is to say, let's go slow on thinking about liability and be, very thoughtful about assessing the situation. Don't just jump to fair use, preempt any possibility of licensing, and end the discussion before it really gets started. I think of it as, something that's not that different from a vehicle that can go really, really fast. And because of that, partly, it has some risks for third parties. Be cool to buy a car that can go 500 miles an hour. But I think there will be some third parties, who are imperiled by that power. And if we were just talking about vehicles, everybody would recognize that. Okay? But because it's content and because the harm feels attenuated or limited, we don't think of it the same way. But I think of this as a machine that throws off enormous benefits and also some costs. So setting the cost benefit analysis is what the job's about. And there's a lot of stuff we don't know yet. So I'm just sort of, advocating that we've seen some licensing deals come forward. And if you ask AI researchers, do you want access to everything with no strings? Or do you want to have to respect copyright and, have a filter and deal with problems? Of course, they're going to say, just let's do the easy way, right? Because they're technologists. They want to see what this stuff can do. And I understand that. But we don't have to sort of stand aside and say, let's assign some kind of intentionality or momentum to the technology and elevate that to the highest consideration. I think we have to say, at the same time, it can do things, but it may have some costs. So I wouldn't just jump to this story that if you are talking about liability, you're anti-technology, anti-progress, old-fashioned, not with it in this, direction we're heading. And I would resist that. I think that the technological optimism can sometimes lead to technological determinism, which is, look, this technology is capable of doing this, so we have to let it, right? Information wants to be free. AI is hungry for content. When we attribute these anthropomorphic desires and qualities, we've slid over into, kind of reification of the technology. And also, the most important consideration becomes, what does the technology want? What can we do for it? That's not what we should be doing, right? We need to think always, what can technology do for us? And of course, this technology is enormously powerful. And Peter's exactly right. If you ingest, clinical studies and come up with a better version of a pharmaceutical, that is as fair use gets. Nobody would argue with that. But I think for creative communities, the output of AI is far more of a threat rather than, just delivering benefits. So anyway, that's my diatribe.
Yeah. So let me just briefly react a little bit. I mean, I think we're at kind of a hype and a pre-monetization stage, which happens, with crypto, and we've seen in a lot. And I'm not comparing this to crypto, but I'm just saying there's a lot of hype and we don't really have a clear vision of what's going to justify the market valuations. There's just, a lot of excitement, and it is astounding what these technologies can do. And but we haven't yet cured cancer using the technology. We haven't yet made, people are saying these are around the corner. And I think we want to do everything we can to try to, encourage people to find those uses. But to the extent that, people are just going to create some music composition application and they're going to train it on popular works, it may be good at doing it, but I don't think that would be fair for that ecosystem. I mean, we want to have humans whose works are, are responsible for those. And, I've already done those experiments. I've asked to have songs produced in the style of Bob Dylan about copyright law. And it's a great blowing in the wind about copyright law. And it's amazing that it could turn it out in little more than the time it took me to type it in fact, less time. And so that's quite astounding. I mean, it's a great parlor trick. But should that be permissible? That, I think, will be what these cases develop. And, I think if the New York Times or other reputable publishing industries want to get involved, and they can both advertise and produce better content, the best of the news services, and people are willing to join those services and to subscribe to them, just as they do to the New York Times, that would be good. If people stop subscribing to the New York Times and we lose all of that fresh input, what's going to substitute for it? You can train on generative AI results, but it isn't going to be the same. So these are, big societal questions. They're starting to be asked. And I think judges are going to play a role because Congress is waiting, is not jumping in, and the Copyright Office has not jumped in. But I think that it would be good to get all of those institutions working, asking the hard questions.
It's a lot of excellent points to unpack there. I think a lot of the things both of you have said goes into the fairness aspect of the fair use. The fairness is, I might be wrong, but at least to me, the fairness part was not as usually often mentioned for the fair use. But I do think, particularly for the AI age, we should, reflect on what fairness or fair use means in a scenario. So I'm very, Rob, so in the 1990s, you wrote 2 articles. One of them basically made the same warning you just made, that if, as a government or court intervention to the market mechanism, if fair use is granted too early, then this might preempt the forming of the market mechanism, might prevent people's investment in market institutions to deal with this problem. So I really think, we should reflect on that point at the beginning of the generative AI age. So I think we only have like about 10 minutes. Even though I have a lot of other comments and questions, I think we better, look at our audiences if there are any questions here. So I think everyone, Peter and Rob, you guys can see.
Yeah, so there's a question regarding the fair use factor of transformativeness. That term is speaking to the infringing work being transformative in the artistic and creative way. To expand that term to a broader sense of utilitarian way would be against the original intent of the Constitution's goal to encourage and promote the works of authors and artists. What do the panelists think about that in the context of the software copyright fair use cases decided by the Supreme Court. So first of all, I think what the Warhol case is saying is that you have to have an independent justification. Just taking someone's work as raw material and doing art that some judge says, oh, that's really nice art, or that's better than the original, that's not enough. And that, I think, is a really important principle. But what your question goes to is the idea expression dichotomy. And there's not a lot of Supreme Court case law in the software area. You've got the Oracle Google case. The Lotus versus Borland case was affirmed in a 4-4 tie. And so the First Circuit decision stands. And I think it's a very wise decision. And in many ways is parallel to the Oracle Google decision. But I think the Second Circuit's case law on software protection is very good, the Altai case being the most prominent. So in general, I think that advances, software doesn't fit squarely in the copyright mold. It was created, it was brought into copyright, I think largely as a way to discourage piracy of software, but not in any way to protect function. And so that's the line that I've always drawn. I think you see it in the Sega Accolade case, not a Supreme Court decision, but one that I think is referenced in Oracle Google and with, in a positive way. So I just think that software, doesn't fit the model. But what's really different about generative AI is it's not a software technology. It's really a mixed technology where you're ingesting all kinds of works that are highly creative, highly expressive. And those works are being sort of processed in a way that creates outputs. So really what's so interesting and exciting about the generative AI area from just a copyright standpoint is that it lies in between the Google Oracle type of case and the Warhol type case. And, the Texaco case, I think, is perhaps closest in a certain sense, in that you had, Professor Chickering, who was ingesting these articles, but making copies along the way. And the court said, well, making the copies is a step too far. Now, I don't think it's a direct analogy, but I'm just saying that there is no clear precedent. The Authors Guild also is not a direct precedent, because here the outputs were a lot like, Sega v. Accolade. You were outputting something that was not the expressive work. You were just saying, here's where you can find that phrase in a book. And so the ingestion there had a very limited role. Whereas now we're seeing ingestion that can produce, some version of the original work in some outputs you can get. And even where you can't see that, you're creating competitive works. And so this isn't being done as an experiment. In order for OpenAI to justify their valuation, their market cap, they're going to have to generate a lot of revenue. And that's going to enter into the analysis.
Wonderful. So are there any other questions? Because I think some of the questions are addressed to our speakers individually instead of collective.
I'll read the question, and Rob, you can take this one. I'll follow if you'd like. Could you weigh in on the fact that because it is a defense, fair use is a great weapon against small actors and a very strong tool in support of larger actors? How do you think this plays out in AI or generative AI, where there's huge investment requirements to run LLMs? Well, you've sort of answered your question because I don't think OpenAI is a small player. And I think some of the people who are suing, are individual authors.
Yeah. I just want to say about the topic of liability that, you were emphasizing the way the conversation has started, or the focal point now, which is, are you extracting or are you, making 1061 reproductions? And if so, what follows? But I think it's quite possible that even though it's only an intermediate copy, that some of the downstream effects from a 1061 violation could lead to liability, even if the output is not substantially similar to a particular, inputted work. That is to say, as a remedy, to say that some of the, collective mishmashing of individual images has created some value. If you can trace that back, either to specific images, which I know is rare, but even to just the collective, I think the question then theoretically becomes how much is any one individual harmed in having their work ingested and used to train without their permission. The easiest way to resolve that is to require permission. And then, that would be a solution demanded by the, avoidance of rushing to fair use at the beginning. In other words, the courts might say, we think there may be a liability here. And we've had some big portfolio licenses, Getty, New York Times. Could we see the emergence of some other mechanism or an indirect compensation mechanism or, the kinds of things I'm thinking of?
Yeah.
Peter.
So let me say, I misread the question, or I didn't read it carefully.
Yeah.
So the questioner is really asking whether this defense imposes such a high litigation cost on a small plaintiff. And so really the class actions that are being brought are indicative, or at least a partial response to that issue. Yeah. Secondly, the New York Times is a somewhat big player. They're not as profitable as the Googles and the Microsofts that they're going to have to go against, but they, I think, are serious. And just today or yesterday, 8 other newspapers filed a lawsuit. So I think we're going to see a range of players. And although I'm not usually a fan of litigation funding models, that may come into play. But I think we will have big enough players on the plaintiff side or class action that we could see, some relatively fair fights in terms of the litigation war. But you can see that you can
thinking ahead,
expensive litigation.
Today's class action could be the genesis of tomorrow's clearinghouse licensing system. I think what's happened is that the interest group of content creators is being pulled together through the mechanism of these class actions and the conversation. It's not that different, Peter, from how Eldred pulled together an anti-copyright coalition. And even though they, lost the Supreme Court case, the organization that survived became very powerful. So they were all scattered until they realized, oh, we have an interest in this and we share it. And that helped create a constituency. So it may happen here too.
Well, you had record labels and music publishers that are pretty big, but you'll remember that in the file sharing cases, a lot of the artists did not want to be seen publicly going against their fans, even though there were a lot of there were briefs filed on behalf of many of the leading artists. They just didn't call attention to it.
But this is different, obviously.
Yeah, I think that you're going to see some, I think this is going to be very profitable for lawyers for the foreseeable future, that there's going to, this is kind of like, what happened with patent law when business methods and, software became a very hot item. We're going to see big copyright cases, getting going, and we'll see some shopping going on in terms of where they want to bring those cases. Yeah. And I think the judges are, going to have to learn a lot of copyright law and a lot of civil procedure pretty quickly to really take this on.
If you're taking bets on long-term consequences, you might put a few bucks on this one. We might get a federal right of publicity out of this if the right of publicity cases start going all over the place, which as state law, they might. We don't really know what the publicity right law is in Arkansas because there's never been a case, or Idaho. But all of these places are, now going to be competing with New York, California, Indiana, the other publicity rights, Tennessee, the other publicity. So anyway, that's a side issue, but
yeah, no, this is just an explosion. I thought, things were going to get a little more calm, but apparently
not in our field.
no.
Thank goodness.
Wonderful. So I hesitate whether should I cherish the last minute to ask Rob a question regarding maybe you just go beyond the doctrinal level a little bit, because I really like your Justifying IP book. And that book you mentioned, you discussed the operative principles, the mid-level principles, and I found quite useful in the AI context. But in short, you talked about the principles of dignity and efficiency. I'm curious, do you see these two principles might have certain kind of conflict in the AI training context, or, not?
Well,
Or
they
if
might.
there's a conflict, how do you, yeah, sorry, go ahead.
But it's also possible, that they would overlap or point to the same outcome. I think, one defense of not rushing to fair use is just to make sure we weigh the impact of this on actual creators and artists. And that's probably a nod to the dignity principle, because we think what they do is valuable. Right now, especially since the benefits are so obvious and the costs are speculative, if we had to make a cost benefit right now, we might just say, well, let it go. It's another topic for another day, but one of the problems with fair use is that it's a one-way setting and it's a one-time setting. If you say fair use, it's hard to go back to property. And if we say fair use at time 0, it's very hard to change anything at time 1 or 2. So
Rob, let me
maybe
push you a little on that, because one of the real, I think, insights from the Warhol decision is that we got rid of the idea that a work is fair. We now talk only about the use. And if you read the Texaco case, it's very clear that they were focusing on use. And I think that's been in the law. But the other thing that happens is that the balancing factors can change over time. So uses that perhaps might be fair because of the transaction and institutional story that you would tell in time 0 could change. We never got, for example, litigation over commercial skipping. We never got a resolution over the litigation of commercial skipping in DVRs. The company went bankrupt or pulled out, and there was no resolution. But that would have perhaps been different than the Sony case on how that. So I don't think that we're locked in as much.
I would point to Sony, Peter, and say, I know you're right, but it seemed like after 1984, no one was even going to consider revisiting fair use having anything to do with VCR. So I think you're right, sort of doctrinally, but I think practically people might say asked and answered. Maybe you're just more optimistic.
I think Justice Sotomayor is really, focusing on the nature of fair use. And in the majority opinion, there is this sense that this is a dynamic framework, and that's we're going to evaluate uses, because we never resolved, for example, we didn't resolve entirely, like, what about the uses of the orange Warhol, in different media or for different purposes. But as a commemorative for Prince's death, it was not fair use. So it might be fair use. So, and I think with generative AI right now, there's this view that you just need more and more data. But we may, in 5 years say, well, you only need so much in order to be able to do good language comprehension. So this idea that you're just going to suck in everything, and the other thing that you and I have talked about is an opt-out regime might be a better regime, for example, for people who want to scour the internet. And we should say, if your work's on the internet, you need to police it. And if you don't want to be ingested, then you need to set a toggle, a digital toggle that will prevent it. And then, that's like the Ticini case. Ticini got angry because the New York Times didn't include him after he won the case, saying that they had to pay him. And they said, well, we're going to opt you out. And so, that may be another way in which we can solve parts of this ecosystem. But, if you're doing a music venture and you want to pull in all popular music, that's going to be a somewhat clear use, and we'll be able to learn. And if the outputs are entirely unrecognizable, the artist Moby, he apparently created all his music just by remixing other stuff into unrecognizable form. And I don't think he was ever sued over that, but someone could argue that that's what's happening, but that might not be exactly what happens. And we know in the graphic works area that people are outputting, cartoon characters and other clearly protectable works. So it may vary, music may be different than graphic art, but, news will be interesting because it's somewhat thinly protected, but apparently even OpenAI thinks that there's some value in licensing that.
Yeah.
So,
I think if you're going to take a consistently pro-creator, pro-artist point of view, then you've got to be quite, generous about what do you allow to be copyrighted. Works created using these tools, as long as the tools were fairly constructed, I think should be perfectly protectable. And, these are going to be tools that can amplify the reach of a creative person. I think as long as the tool's fairly created, whatever people make with it, to me, should be protected.
Yeah. Well, another way to think about this, one of my favorite cases is Tiffany versus eBay, trademark case where eBay recognized that they were going to be subject to these counterfeit kind of cases. And so they built, without a legal requirement, a whole engine for trying to prevent counterfeit, especially in the luxury goods market. And the court essentially said what you've created is akin to the notice and takedown regime we have in copyright. And we think that you've come to a good resolution, a good balance. And so, I just think that companies—
That's an example of a good cost benefit outcome. They tweaked the machine to protect third parties, and it didn't kill the machine, but it did add to their cost. But it really did protect a lot of third parties, and it protected the niche of resale of, sort of heirloom and super popular branded goods, which is its own ecosystem, and could have been just sort of steamrollered if the court had gone too far and said, it's too hard. They didn't intend to infringe any particular brand. You could play that game of intent. You didn't intend this particular instance.
And they preserved the market for resale, which
exactly.
And so that's what we need to start.
That's what I'm talking about.
And I think, I think some of the technologists can do that.
I hate to interrupt, but we are like 8 minutes past, and our staff really have to go. So maybe one minute for each of you. I'd love to carry this conversation over.
No, I'm good. I've said my piece.
Okay,
I'm good.
great.
Dr. Howe, why don't you take the last minute? Because you did so much.
I just want to
bring this off.
Thank you so much for everyone, for Peter and Rob, for this terrific discussion, and thank you, Justin and IP House for. It's actually the Labor Day holiday in China, and IP House is actually sacrificing, his his holiday to live stream for us. And but not least, thank you, our audience, for staying up with us to the last minute. It was just terrific. And thank you. Hope everybody has a great day. Bye.
Thank you. Thanks.